welcome Robert.
In our office, people usually come and say, if I die, God forbid. God will not forbid death. Whether you like it or not, you are going to die. I hope by the end of the day, tonight, you go back to your homes and write your wills. What should we note before writing our wills? You must be at least 18. The law currently as it is says 21. But because of the constitution, the law is older. Our Succession Act dates back from 1906. It's 110 years old. You must be of sound mind, meaning you must be sane and sober. The will must be of your own making. Duress, undue influence, void the will. When you make a will, you must have your will. That's why it's called a will. It's from your own. If it's forced, it's not a will. It's not valid. Testamentary intention. There is a difference between a will. That's number 4. There is a difference between a will and a gift. You can make a document which is a gift, but it's not a will. So a will operates after you are dead. And there are so many cultures in this country where children grow up and tell their parents that I'm now old, I'm getting married, give me my part. Your father and your mother's property are their property until they die. You have no share in it. So a will is supposed to operate after the death of the maker. That's why that person can change that document at any one time before their death. So a good will should have the following things. The date. Why? A later will revokes or amends or alters an earlier one. So we must know which of your wills is later or which one is earlier. Marriage, under the laws of Uganda, when you marry a person after making your will becomes invalidated. So we must know your marriage and your will, which one preceded which. So if you make a will after your marriage, that one is valid. But if you make a will before and you marry another person, that will becomes invalidated. The will must have your names. It's not uncommon to have a group of people following up the estate of Mukasa Joseph, and they get letters of administration and register on property belonging to another Mukasa Joseph. It's very common in Uganda. So the will should name the beneficiaries, the persons who are going to benefit under it, the list of the properties you have and who gets what, executors or persons who are going to implement the will. Those are very important people. Those are persons who are going to implement your decision. So you must elect people who are of the highest moral caliber. Why? They have the authority to sell everything you've left and disappear with the money. I'm not saying the authority says disappear with it, but they have the authority to sell it, and then they can consume the money and run away, or tell your kids, sue us. So the people you appoint to execute your will, because they will be the ones to say, he said this property goes to child X. Those people will be the ones, all your titles, all your bank accounts will go into their names. And then they will be the persons to sign transfers for your children, or to withdraw the money and give to your kids or your spouses or spouse. The will must have a signature of the maker or a thumbprint. The will must have at least 2 witnesses. A will must have at least 2 witnesses. If it's not witnessed, it's not a will. If it is not signed, it's not a will. If it has 1 witness, it is not a will. In Ugandan law, every one of us must make a will which is written. soldiers and sailors, people who are going to combat, even soldiers, except if they are going to combat, those are the people allowed to make verbal wills. But after you come back from the combat, when you have survived, your will becomes invalidated. So a will is a document written to dispose of your property after your death. Executor, person who will manage your estate after. I said I because I don't want you to think I'm referring to you dying. So a person appointed under my will to manage my, not yours, after I die, not you people. Probate is an order made by court giving an executor power to distribute the estate. When you make a will and you say Robert Bogere is going to implement it, it doesn't mean I start right after your death. I must go to court and the court must prove that I must prove that that will is valid. Then the court will give me what they call probate to come and transfer your titles into my names, transfer your bank accounts into my names, and withdraw your money and distribute it as you said. A codicil is an addition or a supplement that explains or modifies or revokes a will. When you want to simply change that I had a certain property but I have sold it, you don't have to write the entire will again. Simply write another document, maybe a page, which must also be dated, have your name, also be signed by you, and also witnessed. It must fulfill those things. But it can simply say, I had named my heir as Bogere, but he has become a drunkard, therefore my heir is Robert. And you sign. That one changes what you did. You don't have to write an entire will again. What can I dispose of in my will? Only the property you own or I own. I may only distribute property due to me in the future, like pension. Or you can distribute property which you are supposed to get from your father's estate. Don't distribute property in which the ownership lists your names and at least one other living person as joint tenants. Who can be a beneficiary under my will? Living persons, children, spouses, friends, dependents, government. I work for the state, so I have to speak for us. The Department of the Administrator General is part of the Ministry of Justice. And you can decide out of your own goodwill to give us something, to put up a hospital. You can also give faith-based organizations, NGOs, orphanages. The only caveat is if you are to leave your property to charitable purposes, to an NGO, to a church, your will must be made at least a year before you die. People who are disqualified beneficiaries, a person who drafted your will should not get a share, because we want someone who has no interest in your will. Witnesses to your will. We had a lecturer at law school who had problems with his wife, and when he was teaching us this topic, he said, I wish I can make her a witness to my will. I may not sleep that night, but she will also not get anything. I'm not saying you do that. It's very, very cruel. That's why the cultural practice is that family members should not be witnesses to wills or should not know the contents. Your spouse should not be a witness to your will. If she is, the will is valid. You get it? If she is, if your child is a witness to your will is valid, but your child will not get a share. That's what it means. The will remains valid, but we count that property which you gave them was not distributed. That means we bring it back into the pool of property which was undistributed, and it is shared by all of them again. Because whatever is undistributed in the will, no, he can get now there, because we say the deceased did not distribute this property. So we look at it under the law which governs property of a person who left no will. That bit which, if I give you a house and you're a witness to a will, we make the house get out of the estate of the will and say the late never distributed this. What does that mean? Every property which is not distributed in a will, we share it equally. It means unless your brothers and sisters forgive you in courts and say let's give it to you, some of them can say no, we want equal share because our father never distributed. Why is it that there is no law which says your parents should give you property when you are above 18? If you are above 18, your father can refuse to give you anything, and you cannot take him anywhere because you are an adult. It's only minors, minor children, and maybe persons who are under incapacity, even if they are adults, but who are dependent on the late. You can have a brother who is mentally disturbed and you are taking care of him. If you don't leave him enough property to take care of him, he can go to court. People caring for him can go to court, and the court will alter your will. A beneficiary who is convicted for murdering the testator cannot get a share. This is very common. Some of the sons, when they look at their father's wills by chance and they see an acre in Kololo, he says the man is not going soon enough, and he disposes him off so that to make the will come into play. You don't get a share. Some of us also give to our spouses. You give to your spouse and say, my wife Jane, then you die without amending your will, but when you divorced, she no longer fits that description, so she cannot take that share. So, contents of a will, as I've said there is no standard format. As long as your will expresses that it is something you want to operate when you die, you have it dated. You have it, this is my last will and testament, although it's not mandatory. The shortest will on record, someone just put a date and said, I, Robert Wogere, all for son. All for son. Like saying, all for my son. All my property is for my son. Signed it, witnesses, and he died. The job he gave the world to look for his all, and he's give the things to the son. And that person is better than you people who write your wills over seasons, because you want to wait for whoever is going to anger you and you strike them out. You need to declare your marital status, your wife's names, and your children's names. Although, even if you don't declare them, it does not make your will invalid. As you've seen, I've not said it's an essential. It's good to have. But even if you simply say, all my property will go to my children and wives, and you die, that's a will. And you sign it and have it witnessed. That's a valid will. It's better than the person who writes the will, puts his names, his date of birth, his father, mother, and their dates of birth, and then he says, Wompaka wala, you know those totems of ours. I belong to the Lugave clan. Our drum sounds like this. We have them. And then each child, when they were born or conceived, and the date of birth. And then in the end, no witnesses. In the end, some of them say, whoever sells my property will see me. Where? Where will they find you? Make your will The president made his will. Otherwise, he would have said, Besigye. He made a will. He said, we talked about it. It's not a private thing. He talked about it and said, because he's not a fan of distributing land, of demarcating it into small plots. The best thing you can do if you don't want your kids to sell your property, put it in a company. You are land people also. Put it in a company, the property, let the company own the property. And then you give your kids shares. The one you know is the best among them in sense, give them the bigger share. In the end, what that means that they can only sell their share. But children, being children, they can all gang up and sell the company. So ultimately, that's why you see under the law, you are not allowed to give those provisions which we find in most our wills, that whoever sells will receive me. That is an illegal provision. What are the benefits of making a will? It reduces disputes that often arise upon your death. It does not take them away. It reduces costly litigation. When you leave your will, you decide how to distribute your estate, not the courts. It's up to you. You know which child is sober, which one is not. You can provide for minor children more than adults. Under the law of intestacy, if you don't leave your will, all your children get the same share. The 2-month-old child and the 60-year-old child. Now, under the law of marriage, your wife is the only wife you married in church, if that was the first marriage. I don't want to go away from it, but let me conclude this. Okay, I think I've concluded it. The last slide says, make your will today, otherwise your family will stop being a family on the day you are buried. Your husband married you in church, and then he has another woman, customarily married. The legal marriage is the first one of those two. You can be married in church, but just be there when you are not a wife. A church marriage is not superior to any other form of marriage in Uganda. Most Ugandans marry customarily, then go to church. So you person, unless you remain with that one woman, if you marry a woman in custom, you already married by the time you go to church. And lastly, on marriage, if your husband, as I've said, women don't die. If your husband dies when you are separated from him, just by a day even a few hours, like you see, I'm a short guy, so you say, we quarrel with you, you start saying, you short man, I don't love you anymore. Then you pack up some of your things and you go out. Now as you are proceeding down, I get too much love, heart attack, and I collapse. The law says we were separated. That's what the law says. It doesn't mean separation in court. It says, were you separated as a matter of fact? It is possible for a man and a woman to be separated in the same house, but proof is very difficult. So the law says the moment your husband passes on, when you have kunobad, you have gone away, this is trial separation, you don't get a share, except if you go to court and notify court that in case my husband dies, I should not be left out. Now, if your husband finds out that you even made that petition, he may say, is it she anticipating that I'm going very soon? So, but we want to change that law. Why? Some of us men beat our wives. The wife, you beat her up, she runs to save her life. It's as if the law is telling her, don't worry, let him break your arm, knock out your teeth, stay. for the property.
Yes, that says it all.
The intention is I want to get something. Can a minor be an executioner? Probably maybe under guidance of an adult. Thank you.
I have a scenario which happened 3 weeks ago. I went and attended the burial. In this burial, the old man became mentally derailed for about 2 years, in which case he was not able to write his will. But at one point in time, he tried to confide in a few people who witnessed verbally and said, when I die, so and so will keep my home. He's going to be my heir and he will also take over my estate. The will was not written. So, on the day of the clan meeting, people rose up and said this was a total lie. Nobody can believe in this kind of thing. And they instead decided not to listen to what these people were saying. So, my question is, if in this case a will is not written, can it be honored?
Your name?
My name's David Odilon.
Presentation. Mine is about, you said if a lady parts and leaves, then you don't benefit. What about where men live?
It said that a will must be written, but with the advent of ICT and the changes that we're having in technology, if someone actually did a DVD of their will, so you can actually see the person and they are speaking and saying, speaking everything rather than writing it down, would it be valid?
If it is registered, kindly clarify on that.
Mine, I am fortunate or unfortunate to be a leader of Rujia and Mutua. So I have a lot of challenges in areas you handled here. I thank you for ably handling them. But there is an area where I'm left with a challenge. I have a will in my custody for one late. He didn't identify witnesses, but he identified, he made carbon copies to 3 other people. Now, can we by this take them as witnesses or not? Thank you.
I've already written my will, but who should I entrust? Yes, I've written it already. But who should I entrust my will? Should it be my lawyer? Should it be my friend? Should it be? And 2, we have property in joint names in my wife, together with my wife. Now I'm wondering if for example, if I die and then my wife changes her mind, like for example, changes.
And she remarries.
Yes. Can she, can that, will that, I'm now worried because she can write a will, giving out something to someone I didn't want to give the property.
A situation where there is no will, who are actually the beneficiaries of a property?
Intrigued with the statement you made about women not dying, and so it just tickled my mind a bit. In the event that the woman died before the man, how would that will then be written by the man?
God forbid.
Say women don't die.
Belongs to her spouse and children and the dependent relatives. So it's the same thing as if the man ups and leaves. If the man leaves, the problem in Uganda, which is not like in the developed world, our societies are patriarchal. It's the woman who moves to the man and goes to his property. But if I get married to Bad Black and I'm staying in her house and she dies, I'm the widower. So I'm entitled to the house together with our kids. The problem was before previously, and to answer, I think Lawrence, who did not want to envisage his wife remarrying. When you are dead, you are dead. Stop those things of saying, my wife should never remarry. Some of you don't know how many wills we read and we just burst out laughing. If I die, my wife should never remarry. If she remarries, she should never take even a cent, and she should repay back all the money she consumed between my death and her remarriage. Thank you very much.
Really done justice to this.